Hi, Tyson Mutrux here, the Mutrux Firm Injury Lawyers. And today I want to talk about bad faith claims. And I'm not going to talk about the legal definition of bad faith claims because you probably don't care about that. I'm going to talk about what it means practically and what it means for your case. In a nutshell, what bad faith means is that the insurance company is screwed up. They've offered an amount less than what your case is worth. And because of that, they've exposed their insured, the defendant, to additional personal liability. And then if that happens, their insured can sue the insurance company. And so the benefit to you is instead of having a $25,000 policy limit or whatever the policy limit might be on your case, we call it blows the cap off the policy. So it doesn't mean that you're entitled to unlimited funds. It does mean that you are entitled to an amount that your case is worth instead of whatever the policy limit is. So I'm going to walk you through the process and give you an example of a recent case that we had. So what we do is we send our demand. We almost always send it for policy limits, and there's a reason for that, but it's just a part of our process. So we send that for the policy limits. We wait for the response. Once they respond, if they respond with something less than the policy limits, we send what's called our hammer letter. Basically, we're pulling our demand off the table. Our demand is now something much higher. So let me give you an example of a recent case of how that worked. So it was a $25,000 policy limit. We send the demand for the policy limit. Clear liability case, clear damages case. Our client was definitely injured. All right. So they respond by offering $13,000, significantly lower than what the policy limit is. We then send our hammer letter saying, you've screwed up. We've now pulled our policy limits demand, and our demand's now $150,000, all right? Then we CC their insured, the defendant. So we send them a copy of our correspondence with the insurance company and let them know, hey, your insurance company screwed up. We don't say that directly to them, but our language in our hammer letter that we send to the insurance company that we've CC'd to the defendant, they get to see that, hey, the insurance company screwed up because our language is very direct to the insurance company saying, hey, you've messed this up. Now you owe us more money. What happened in our recent case is once we sent that, about a week later, we got an email from the defense counsel for the insurance company saying, hey, we're offering you the $150,000. And that's why we do it in a very specific way. We've got to follow certain protocol to be able to set that up. Otherwise, it won't work. And if we were to do any negotiating after the fact, so let's say that after the $25,000 demand, they offer $13,000. And then let's say we make a counter of $22,500. That throws everything else off. And so bad faith is no longer in place. So you have to do it in a very certain way. Hopefully that answers some of your questions. If you have any questions, give us a call, 888-550-4026. You can also check out our YouTube channel, Mutrux Firm Injury Lawyers. We also have a lot of other great information on our Facebook page where we share things every single day. So check us out there as well and give us a like. Make it a great day out there. We'll be seeing you. Thanks.